Mr. Kelsey is here today after failing to appear before referee Snyder on September 12th, 2023. Bond is currently set at $4,488. This is the fifth bench warrant. He reports that he is self-employed. The last payment made on this account was in November of 2021. The court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on January 17th, 2024 at 8:00 a.m. before this court.
Mr. Kelsey, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 17, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, may I also say something?
Go ahead.
Every time that I come here, you guys release me, and then I go to Oakland County for 6 months to a year. I get a warrant while I'm in jail, and then nobody comes and gets me. I get out, and then I come back here again. It's not that I'm not trying. I always have a warrant from either Oakland County or you. You guys never coincide with each other. When I leave here this time, I will go do 6 months in Oakland County, and I will get a warrant from you guys by the time I get out. And this is what's happening over and over and over again, and I can't stop it. This is all I'm trying to say.
Okay. Well, next time when that happens, make us aware at the time of the hearing.
I do. I write you
Okay.
guys.
But the other aspect is that you haven't paid support. And
I'm not going to
okay. Well,
until we figure it out.
okay.
Because I keep going to jail for this over and over again. When I'm already in jail, and then I get out of jail and I have to go back to jail again, I can't keep a job. I can't get anything. I can't get mental health. I can't do any of my life
Okay.
because I'm always in jail
Well, why are you in jail in Oakland County?
for child support,
Okay.
for felony child support.
Well, what I'm going to do is I am going to set your bond. I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $1,000. If you're able to post that, you'd be able to be released. Do you have any questions?
Nope. Thank you.
Okay. Thank you. You're excused.
Mr. King is here today after failing to appear before referee Croteau on April 21st, 2022. Bond is currently set at $704. This is the second bench warrant. He does report employment, but I am unable to read what he wrote. The last payment made on this account was in June of 2022. The court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on January 17th, 2024 at 8:00 a.m. before this court.
Mr. King, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 17, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I don't know. I've had a job for the last couple of weeks. My twin brother had passed away almost a year and 3 months, a year and a half ago. So it's taken me a little bit to get back on my feet. It was a big loss for me. And I live with my mother, and she's 77, and she can't take care of the house by herself. If you look back in my records, I've been an iron worker for 20 years. I've always paid my child support. And if you would,
But you haven't paid it for a year and a half, sir.
and that's because my twin brother passed away, and I couldn't get my head right.
Unfortunately, people have relatives that die every day, sir, and they still work and they still pay their obligations and pay their bills, etc.
I understand that. And that it's on me. But I mean,
Well,
if I could be, I could have $800 by Friday. I do have a paycheck waiting at home for me.
okay.
What
What I'm going to do is I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $500.
Okay.
Once you post that, you'll be able to be released. Do you have any questions?
No, sir.
Okay. Thank you, sir.
Thank you.
Have a good day.
I appreciate it. Thank you, Your
Ms.
Honor.
Sheehy is here today after failing to appear before this court on March 1st, 2023. Bond is currently set at $1,299. This is the third bench warrant. She does report employment, but I am unable to read what she wrote. The last payment made on this account was in January of 2023. Friend of the court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on January 17th, 2024 at 8:00 a.m. before this court.
Ms. Sheehy, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on January 17, 2024 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No.
No. Okay. And are you working?
I was going back to work for my previous employer, Air Quality Experts,
Okay.
but I probably won't be now.
Well, you've got a sizable arrearage in this matter. The court will notice your third bench warrant as well.
My
And
daughter's 18.
you haven't paid in almost a year. So the court's taking all that into consideration. I'll reduce your bond. I'm gonna set it in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, thank you.
Okay, thank you. You're free to go. Have a good day.
Attorney Wesley Todd for plaintiff, defendant, and counsel are not here.
Okay. Good morning to both of you.
Good morning.
Morning, Your Honor.
Court would note, Mr. Todd, I know we checked last week and the plaintiff had not paid the mediation fee at that point. Has that been taken care of?
No,
Okay. Well, let me tell you, ma'am, until that's paid, the court will not enter a judgment or complete the case. So you'll need to pay that or the case will not get completed. And if it drags too long, the court will then dismiss the case if that happens. So
I was not aware of that. Thank
Yep.
you.
you'll
I
need
didn't
to
know
take
that.
care of that. Okay. Ms. Doubleday, I guess we're going to take some proofs from you at this point. Go ahead, Mr. Todd.
Thank you, Your Honor. Ms. Doubleday, do you remember signing a complaint for divorce?
Yes,
At the time you signed that complaint, were all those allegations true, and do all those allegations remain true today?
yes,
Did you live in this county for at least 10 days in the state of Michigan for at least 180 days prior to filing the complaint?
yes,
Have you had an opportunity to review the proposed judgment and believe it equitably divides all of your assets and debts?
yes,
Are you currently pregnant?
no,
Have you had an opportunity to review the custody, parenting time, and child support provisions and believe they are in your children's best interest?
yes,
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
yes.
Would you briefly describe for the court why that is?
My husband had a drug problem.
Nothing further, Your Honor. And I guess beyond that, we did have a motion set for 9 o'clock. We do have that resolved. I sent a message to the clerk, but I'm not sure if it went. I'm not. Jesus said it wasn't you, so I'm not sure if that's still on the court's calendar. But we do have that resolved for today.
Okay. Nope, I hadn't taken it off yet, but we will do that now. So, okay, thank you. Court will find that the testimony does satisfy the statutory requirements. The court will find that there has been a breakdown of the marital relationship in this matter. The court will preserve the proofs pending receipt of the paperwork and the payment of the mediation fee. And at the time that that occurs, the court will then enter the judgment. Ma'am, you're not divorced until I actually sign that. And but once those things get taken care of, then the court will enter the judgment. At that time, you will then be divorced. So
Okay.
best of luck to you, ma'am. I hope everything works out for you. Court will conclude this matter at 8:44. Court will note the appearance of Ms. Thomas on behalf of the plaintiff, Ms. Camfield on behalf of defendant. This matter is before the court on the plaintiff's motion to show cause in this matter. Ms. Thomas.
Thank you, Your Honor. In this case, the case scheduling order required the parties to participate in mediation in the month of December. And as it shows on the Register of Actions, mediation was canceled by Mr. Brundage because the defendant did not, in fact, pay mediation fees prior to the mediation. She is in violation of the order of this court, causing failure to move forward with this case. And so we were asking that we could enter a default and then just simply proceed. There still has to be a ROPA hearing in this particular matter, which could have been done a long time ago, but it still does need to be done. And then we could bring this to a conclusion.
Okay. Ms. Canfield, what's your response?
Thank you, Your Honor. Well, first of all, I very rarely see someone held in contempt of court or sanctioned for having the inability to pay a mediation fee. Ms. Thomas did not contact or communicate with me. If she had, her information and her motion would have been correct or corrected. She indicated at her belief that I had not responded to Mr. Brundage and apprised him of what was happening when in fact I did. And I have an email communication with him informing him that I had relayed the message to my client and she was going to just contact him regarding that payment. Since then, I have spoken and communicated with my client who has the inability to pay that mediation fee of $525 right now. She just gave birth several months ago to the little one that you see her holding on the screen. She is not working. She does not have that type of money to pay for mediation. Now, that having been said, I am happy, as is my client, to informally mediate that with Ms. Thomas and her client, but I don't think that, an inability to pay a mediation fee for somebody who just gave birth and is on maternity leave should necessitate an entry of a default judgment. I think that we ought to be able to negotiate this. I believe that the parties themselves have spoken and come to some tentative agreements that Ms. Thomas and I can discuss further and put into a consent judgment of divorce to enter before this court. And I would ask that the court deny the motion and allow us to continue to negotiate to resolve this matter.
Okay. Ms. Thomas, I'm intrigued. What's happening with regard to the ROPA action?
Typically the person that has the child that is not of the marriage is the one that brings that ROPA action, and it has not been brought by Ms. Canfield. My understanding is that that when we were at the scheduling conference, it was actually at the first motion hearing, and another person from Ms. Canfield's office was in attendance. It was my understanding that they were going to be bringing that action, but I've heard nothing from Ms. Canfield since that. Well, and she wasn't here that day. I've heard nothing from her on this case at all.
Well, if she doesn't do it, Ms. Thomas, you're going to have to do it, or there's going to be an order entered, and he'll be declared to be the father. And
no, I understand
that.
He
can pay for 18 years or more if he wants.
No, I understand that, but when I was told by counsel that they were going to bring it, I assumed that that was going to happen. And I've written a couple of emails to the gentleman, and I've not heard back, so I don't know.
Ms. Thomas, may I ask you who was present at that hearing?
I don't know.
An attorney who's left the office.
It could well have been. I don't know. I have his name in my other part of my file, but I don't have it right here. It would be on the case scheduling order, I'm assuming.
Was it Augustine? Enriquez, if you recall?
I don't believe so. That name and the person that was here would not match.
All right.
Well, regardless, Ms. Canfield, is your intent to proceed with the ROPA action, or?
Absolutely, Your Honor. We will get that filed.
Okay.
Looks like Attorney Crow.
My staff says Attorney Crow.
Thank you. That explains things, Your Honor. We don't have the best notations to the file sometimes. So I will definitely get that motion filed and we'll get that conducted.
Okay, well, let's do that. In the meantime, if the parties wish to get together to resolve the issues, if they feel that they can discuss the matters amongst them and get them resolved, then fine. If not, the court will take the motion and I will take it under advisement and reserve any finding on that or Ms. Thomas's request for attorney fees in this particular matter, pending resolution of the case.
Thank you.
Thank you, Your Honor.
Thank you.
Your Honor, before we leave, we have a settlement conference this afternoon. Do we need to still be here for that now that with what we've just done?
No, let's proceed. We'll proceed on the ROPA action, and then we can again at that point that might get things resolved depending on the resolution of that. If not, then we'll set up for trial at that time.
Okay.
Thank you, Your Honor. Ms. Thomas, I'll be in touch.
Okay.
Thank you. Goodbye.
Good morning. First and last name, please.
Hello?
Hello. First and last name, please.
Hello?
Hello. First and last name.
Yeah. Jane, Gene.
Okay. I'm going to place you in the waiting room.
Court will note the appearance of Ms. Smith on behalf of the plaintiff in this matter. The defendant apparently, okay, I thought that was another case then. Okay, we'll bring the interpreter in. I thought that that was on another case, being that we had not brought him in. This matter is before the court on the plaintiff's motion for emergency custody and plaintiff's motion for special finding on issue of special immigration juvenile status. Ms. Smith, you may proceed.
Thank you, Your Honor.
Muchas gracias.
So we're asking the court today to grant the emergency custody order. The parties have never been married, but the defendant is listed on the birth certificate of the child. Ms. Sotorzano has had physical custody and control of the child since birth. The defendant, Mr. Velasquez Marroquin, has not supported Samaria financially despite a court order. Ms. Sotorzano filed a complaint with the Guatemalan Family Court requesting child support from the defendant. The court ordered the defendant to pay 800 quetzales a month, starting in July 2016. The defendant refused to pay or respond to Ms. Sotorzano's requests, so she filed a motion to enforce the order in 2017. During the duration of the support order, the defendant would not willingly comply and only gave a small amount of money when he felt like it. In July 2016, the defendant assaulted the minor child, Samaria. Ms. Sotorzano reported the incident to the police, and the criminal court found the defendant guilty. Ms. Sotorzano then sought and received a protective order, which ordered that the defendant not have any physical contact with the minor or Ms. Sotorzano. Despite the protective order, the defendant's family continued to harass and threaten both Ms. Sotorzano and the minor child until they fled and came to the United States in 2021. Based on these facts, an emergency custody motion was filed with this court on November 14th, 2023. And we ask this court today to grant the plaintiff sole physical and legal custody and further move the court to grant the motion for special findings. And I have the plaintiff and the minor child available for testimony.
Ms. Smith, I note in your memorandum that you had filed in this case that your petition would be appropriate with the United States Citizenship and Immigration Service. And I also have some question, I guess, as to the propriety of the court taking this matter, as it appears that the court in Guatemala has entered multiple orders in this case. So why should this court interfere with the other action that been proceeding in Guatemala?
So the court in Guatemala only, the family court only ever issued a child support order. It did not issue a custody order. And the protective order was issued by the criminal court in Guatemala and would be considered a personal protection order, which is separate from a custody order. And so at this time, Ms. Sotorzano does not have any paperwork of any kind that says that she has full legal or physical custody of the child. Unfortunately, I don't have a lot of the details of what happened. Obviously, she had a different attorney representing her at that time. So frankly, I don't know why that didn't happen at that time, but from everything I understand, it, for whatever reason, it did not happen. And so we're asking the court to rectify that today.
Well, you understand, Ms. Smith, that the court is required to make a best interest analysis, which requires an evidentiary hearing.
Yes, Your Honor. I've prepared both the plaintiff and the minor child to give testimony today on that regard.
Well, we don't take testimony on Mondays because we have tremendous amount of motions in this matter.
Filed a return of service. She told me she was
Oh.
going to file it.
Ms. Smith, staff has just alerted me, we had talked about, apparently they talked to you about getting a proof of service in this matter. Did you acquire that?
Yes, Your Honor, I did file a proof of service several weeks ago, for the,
Return of service.
Yeah, they haven't filed the return of service, like
That-
he's not been served.
That's the proof, though.
Well, she filed the proof of service on the motion, but he's not been served with the summons and complaint.
Oh, okay.
so. Your
Staff
Honor,
just clarified, you filed a return of service for the motion, but there's been no proof of service as it relates to the summons and complaint.
So there is an order for alternate service via publication in the case. And I did, arrange for publication in Calhoun County for the once a week for 3 consecutive weeks. And I did file the affidavit of publication, last week via email and received a confirmation that was.
It's not docketed yet. But,
Okay.
I mean,
Yeah, unfortunately, we don't have it. It's not been docketed yet, so we don't have it, but the clerk's office may very well have it.
I received confirmation that it was accepted for filing on Wednesday, January 3rd.
Well, again, very well, very likely, we'll accept your representation, but it doesn't show up on the computer yet. But Ms. Smith, what we'll do is we will check that this week, and once we have confirmation of service, we'll contact you at that point and set the matter for an evidentiary hearing, and we can take testimony.
Is there any way that we could proceed today with the testimony?
No, we have, I think, approximately 42 hearings today. And as you can see, there's not going to be any time for testimony.
No.
I am a little bit concerned as far as the timing, because it was not, I was not under the understanding that we weren't able to give testimony today. But the minor child does turn 18 soon, and with regard to the special findings motion, there is an issue of jurisdiction.
Well, I don't know who would have given you that impression that we would take testimony. We have never taken testimony on a motion day, and my staff would never tell you we've taken testimony on motion day. So, Ms. Smith, we can, again, as soon as we get confirmation of service, we will schedule the matter and we will take testimony at that time. But I can't do it until such time as we have confirmation of service and have time where we can take testimony.
All right, thank you, Your Honor.
Gracias, su señoría.
Thank you, and we'll be in touch with you. We'll check with the clerk's office and try to track that down and make sure that it's in the file. Then we will get in touch with you. We have some dates that are open, and we could do it on Wednesday afternoon. That would probably be the easiest date to get it in, or day to get it in. So we will do that, and again, get an address from you so we can get service on the defendant, and then we will schedule it in for a hearing.
All right, thank you, Your Honor.
Okay. Thank you. We'll conclude this matter. You have a good day, and thank you to the interpreter as well. Court will note the appearance of Ms. Thomas on behalf of the proposed interveners in this matter. Plaintiff has filed a motion to appoint a third party as temporary joint custodian and allow the intervention in this matter. Ms. Krapoff, that is your motion. You can proceed. Ms. Krapoff, are you there?
Yes.
Okay. Again, it's your motion. So what do you want me to be aware of with regard to your motion?
I just want to do joint custody, joint physical custody.
And you don't have any problem with the Osbornes intervening in this action?
No, sir.
Okay. Well, Ms. Thomas, maybe you can give me some more information.
Okay, thank you, Your Honor. The minor child in this particular matter is living with the Osbornes, and he has been living with them for an extended period. Shania has reached out to them, and she's always been the one, they've always been the ones that have been taking care of Nathaniel when Shania is not available or can't or whatever. And at this point in time, she knows that she's still not able to truly take care of her son without the Osbornes' help, and understands that if in fact they have custody, my understanding is they were going to have physical custody and they were going to have joint legal. By doing it that way, they also are able to get him covered with insurance in addition, and which will give him more stability. Him knowing that there's an order that he does stay in their house does certainly provide Nathaniel with more stability. So on a temporary basis, until such time as Shania is able to pull things together for herself, she's requesting that we have joint custody as far as legal, and with primary physical being with the Osbornes.
Okay. Ms. Crapoff, you understand what Ms. Thomas is asking is that you would have joint legal custody with the Osbornes, which would mean, again, that you'd be consulted in important decisions in the child's life. But again, the Osbornes would have physical custody in that he would actually physically be in their care and custody. You understand that?
Yes.
And do you believe that's in your son's best interest?
Yes.
And again, has anybody threatened you, coerced you, used an undue influence, pressure, or promises to get you to agree to this?
No.
Believe that at the current time that this is where the child should be, is to remain with the Osbornes?
Yes.
Anything else, Ms. Thomas, that you think we need to go over?
I don't think so. I think that there is a proposed order attached that sets forth what the agreement was.
Okay. Court will, again, I'll review that, Ms. Thomas, and see that is satisfactory. And court, assuming that it is what we have talked about in court today, I don't have a problem with that. Anything else, Ms. Thomas?
Nothing, Your Honor.
Ms. Crapoff, anything else on your behalf?
No, sir.
Okay.
We may need FOC approval on that order. If that's a
Okay.
final order.
Ms. Thomas, is that a final order or?
Well, it's a temporary order because that's what we'd asked for, was temporary. That's why I didn't necessarily send it to FOC yet. I can.
Okay.
No.
Nope, that's fine. We just didn't know.
Okay.
I will. In fact, we'll look that up and see, and if it's temporary, we'll get it entered, and then we'd have to have a final hearing to get the matter concluded.
Okay. If the court prefers just to do a final order, I can just send it to front of the court. That's fine too.
Well, why don't we do that? We'll sign your temporary so you have that, but then if you would, you can always get the final order approved and signed by everyone, and then we can get that entered at some point.
Okay. I'll do that, and then I will get front of the court approval and let Christy know.
Okay. Thank you. And we'll end this matter at 9:36 a.m. You're free to go. Have a good day.
Thank you.
Or
Correct. He's incarcerated, and so we had some issue with the writ. But he would like to move forward, and I have his consent to do so.
Court will note the appearance of Ms. Capster on behalf of plaintiff, Mr. Todd on behalf of defendant. This matter is before the court on the defendant's motion for contempt. The motion does set forth that the plaintiff has failed to, again, contact and cooperate with Meredessa Katz in this matter as previously ordered on July 25, 2023. Ms. Capture, why have we not had cooperation from the plaintiff?
Your Honor, as our answer states, plaintiff has attempted to contact Ms. Katz. That was pretty recently. However, she did not realize, because the order does not state any kind of immediacy. As Mr. Todd stated, defendant is incarcerated. He has no known release date. Plaintiff was operating under the assumption that reintegration counseling wouldn't start occurring until defendant was set for a release date. We have discussed that now, and she has contacted Ms. Katz. She's left, I believe, 2 voicemails. I'm not sure if Ms. Katz has responded back to her at this time yet. But Your Honor, she is doing everything in her power to cooperate with the court order. Again, the order did not state any timeline or process for when this counseling would begin. I had spoken myself to Ms. Katz in October, gave Ms. Katz, Ms. Millward's contact information, kind of gave her an overview of the matter. Certainly there's been a delay here, but I don't believe there was any intentional delay by my client whatsoever. Again, Your Honor, as we state in our answer, Ms. Millward is raising 2 children by herself. She works full time. She gets no assistance from defendant. she simply got busy and it wasn't a pressing concern for her. That may have been a wrong decision to make, but she immediately, once getting a motion and speaking with me, contacted Ms. Katz and did everything in her power to begin this reintegration counseling. Her main concern is making sure her children are cared for and kept safe. This is obviously a very tenuous situation between these two parties. And so Ms. Millward acted what she thought in the best interest of the children. She realizes now that she needs to begin reintegration counseling immediately, and she has made the steps to do that.
Okay.
Your Honor,
Yeah, go ahead.
Thank you. Your Honor, the reason why we filed this is she was well aware that everybody wanted to move forward with reintegration counseling. I reached out to opposing counsel, and in fact, the reason why we ended up filing this motion is a text message indicating from opposing party, please stop contacting me and my family. We are trying to move on with our lives. Stop trying to bully me into integration counseling. I am not doing the counseling at this time. If you continue to harass me, I will follow through with PPO. That was sent on December 12th. And the next day we filed this motion because had we not done that, I don't think any of this would be moving forward. And the whole point of reintegration counseling while he's incarcerated is so that when he gets out, he'll be able to have a relationship with the children and kind of move forward a little bit more quickly. So we do believe that she should be held in contempt, and we are respectfully requesting attorney fees in this particular matter because we did try to settle this without filing this motion.
Okay.
Your Honor.
Sure.
Yes. What Mr. Todd fails to mention is that message is from defendant's mother. As I stated in the answer, defendant's mother has harassed Miss Millward on numerous occasions, will randomly show up at Miss Millward's home, at children's extracurricular activities, at Miss Millward's parents' home, will frequently call and harass Miss Millward and her parents. The comment made to defendant's mother was that she needed to stop contacting Miss Millward. Defendant has made no attempt whatsoever to contact Miss Millward.
Miss Capture, if he's incarcerated, he's kind of limited as to the communication, wouldn't you think?
Yes, but incarcerated individuals have the ability to use the phone. That is not prohibited. They do have that ability, and he is able to make efforts to do that.
Okay. Well, what the court's going to do is the court would order, and you can prepare an order with this, Mr. Todd, that the plaintiff would contact Meredith Katz within 7 days of today's date to set up an appointment. Court will order that the plaintiff shall attend counseling at times requested and arranged by Meredith Katz. And the court will, at this point, the court will reserve on the request for attorney fees at this particular time. Mr. Todd, you can prepare that order and submit under a 7-day notice of entry.
Thank you, Your Honor.
Okay, thank you all. Your parents free to go. Todd, on behalf of the plaintiff, Mr. Fernandez, on behalf of defendant, we have two motions, the plaintiff's motion for temporary custody, parenting time, and defendant's motion for temporary custody and child support. Mr. Todd.
Thank you, Your Honor. Your Honor, the parties separated in June of 2022. From June of 2022 through June 2023, the child resided with Mr. Reinhardt. After that, the parties verbally agreed that Mr. Reinhardt would have parenting time every week, Saturday through Sunday night, because of his work schedule. He gets off work a little bit later on Saturday, but he doesn't need to go into work until, I believe, 11 o'clock on Monday. So he's certainly capable of dropping the child off. Unfortunately, defendant unilaterally changed her mind and modified that agreement. So the status quo prior to June of 2022, for the majority of time that the parties have been separated, was that the child was living with plaintiff. We believe it's appropriate that the parties be granted joint legal and joint physical custody. Unfortunately, the defendant has a relatively new relationship, and this person is an alcoholic and has substance abuse issues. Defendant, again, unilaterally made that decision to modify the agreement to 1 day a week, and subsequently this motion was filed. We do believe it's appropriate that the court move forward with joint legal and joint physical custody, and that the that Mr. Reinhardt be granted parenting time of Saturday night and Sunday night every week. Additionally, it's my understanding that the parties have at least discussed the possibility of separating the summer breaks of equal value, whereby I believe the paternal and maternal grandparents would have kind of half of the summer. But at any rate, from a pragmatic standpoint, I believe either every other week during the summer or alternatively each party having half of the summertime would also be appropriate.
Okay, thank you. Mr. Fernandez, your response.
Yes, Your Honor. So I believe the separation, there's some argument over whether it was June or August. Regardless, June or August of 2022, there was the separation. During that summer, yes, the arrangement was Saturday and Sunday overnights because it was the summertime. Actively, plaintiff is really only exercising the Saturday overnight anyway. So in reality, he's been exercising one overnight a week. Ms. Davis would like to have their child for all of the school nights. So she did offer Friday through Sunday, which the court would typically define a weekend as, and the Calhoun policy says that as well. That is typically defined as Friday at 6 or after school or daycare until Sunday at 6. Ms. Davis has offered that every week, all weekend parenting time, but she has established a, school night routine with their child. She's always pretty much been the primary person to help with schoolwork and attend school conferences. He has been doing well in school, and she would like to keep it that way. She believes that part of that is due to the routine that they have established. So that was what led to the decision in changing the schedule. Was once summer was over, she thought it was best to maintain continuity, maintain that stable school schedule, and instead move the overnights from Friday overnight until Sunday. So still 2 overnights, even though he's really only actively exercising one. The concerns about Mrs. Davis's new relationship or boyfriend, they have been together for, I think, around a year now. I don't believe there's any evidence of substance abuse issues or anything like that. The child has his own room at Miss Davis's home. Again, they've established a good, stable school night schedule. She would just prefer that all the parenting time remain on the weekends, Your Honor. And in terms of holidays and special parenting time, that can be per the policy as well. But really, the primary concern is ensuring that the child has a stable school night schedule. So that's why we're requesting that every weekend be Friday after school until Sunday at 6, Your Honor.
Okay.
Thank you.
Mr. Todd, why would not work from Friday to Sunday? He would then get his 2 overnights.
Yeah, because of his work schedule. So he's really unable to exercise that Friday overnight from a pragmatic standpoint. And that's why they agreed to this schedule. And additionally, Mr. Reinhardt would have been exercising 2 overnights if he could have. However, he didn't want to, in essence, play a game of steal the baby. And again, for the first year that these parties were separated, Mr. Reinhardt had full legal, full physical custody and almost all the parenting time. I mean, I suppose worst case scenario, in the event that Mr. Reinhardt is unable to get the child to school on Mondays, Ms. Davis can file a motion to try to modify something, if that is in fact the case.
Okay. Well, what the court's going to do in this matter is the court will not obviously grant full custody without an evidentiary hearing, but at this point, the court does believe, based upon the pleadings and the argument today, that the parties had been engaged in a joint physical custody arrangement. What the court will do is the court will continue that status quo, and that will continue from Saturday at 9:00 a.m. through Monday morning when the child has to go to school. And the court will further provide that and that's every weekend. The court will provide the plaintiff will have alternating holidays. I don't know whoever had New Year's Day, but whoever had New Year's Day would alternate from that date. So the next holiday would go to the other parent, and then we would alternate from there on out. And that we would also do alternating weeks in the summer at this point, and the court would order support consistent with the child support formula and guidelines in this matter. With that, Mr. Todd, you can prepare the order, submit under 7-day notice.
Thank you, Your Honor.
Okay, thank you all. You're excused. Have a good day.
Thank you, Your Honor.
At 9:53 a.m.
Court will note the appearance of Mr. Umlauf on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for modification of parenting time. I've read your motion, Mr. Umlauf, so we don't need to delve into that. Anything else you'd like to add?
No, Your Honor, nothing further to add. It's all in the motion.
Okay. Ms. Wilson, you've been provided with that motion, which is for modification of parenting time. What is your response?
Good morning, Your Honor. I would like to request a 2-week adjournment to seek legal counsel, please.
Okay. Well, I don't see that would present a problem. Any problem with you, Mr. Umlauf?
The only issue is that my client is leaving on approximately February 12th. The training starts on the 14th. But he's required to be there at least a couple days early.
Well, I think you can adequately represent him at the motion hearing. So the court will adjourn the matter 2 weeks to allow defendant to have representation. And then
Thank
we'll
you.
have the matter back in at that time. Thank you.
Thank you.
Thank you, Your Honor.
Yeah, Mr. Umlauf, just send out a renotice so we have it. The appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. Reed.
Thank you, Your Honor. The parties share one child together. That's Joseph, who's age 4. Plaintiff is requesting sole legal, sole physical custody of the minor child. The defendant having supervised parenting time. The defendant has had minimal contact with the child, even though the parties share the same residence. She is taken to locking herself in her bedroom. She repeatedly hits the child, and most recently she bit the child, leaving a bruise on the child with teeth marks. The child is afraid of her, and due to her lack of supervision, the child has been permitted to wander off while in her care. And for all these reasons, my client does not let the child be alone with his mother. There's usually himself or a roommate, or the child is in daycare, so the child is not left alone in her care. Since she has been served, there's been repeated threats to kidnap the child. Last week, she has stated that if it does not go away today, that it doesn't matter what the court is going to do, that once my client gets home from work, she will not be at the home, the child will not be at the home, and he will not be able to find her. For all these reasons, we're requesting that she have supervised parenting time, submit to a psychological assessment with Dr. Calhoun, and my client gets sole legal and sole physical custody. He is trying to find alternate housing to try and alleviate some of the stress that's going on in the house. But until the parties separate, we believe supervised parenting time is appropriate.
Okay. Mr. Pincus, what's your response?
Is that on to me now?
Yes.
The allegations are not fully accurate, Your Honor. I want 50-50 custody, and I request an appointed attorney.
Okay, ma'am, we do not appoint attorneys in these types of cases, so you'll have to acquire an attorney.
Okay, I just wanted to ask. But also, the allegations are fully out of bias. They are out of context. And I am also going to get help for my depression, yes. But I believe that the child deserves 50-50 custody. And I am not saying Jeremy does not have a right. And also, with him knowing the fact of the allegations are not fully understandable. He basically is taking bits and pieces of it, Your Honor. Yeah. And for right now,
go ahead.
If it was the case, Your Honor, if it was the case if he was feeling unsafe with me with our child, why is our child in my care right now?
Well, anything else, ma'am?
No, not seeing, Your Honor.
Anything else, Ms. Reed?
Yes, Your Honor, it's my understanding that the child might be in the care of the defendant right now. She made threats of getting potential PPOs against child care providers to bolster her case, and then went back on those threats. We don't know how valid those threats are, but that was part of the threat of kidnapping after today's hearing, was that my client wasn't allowed to permit the child to go to child care today, so the child would be in her care pending the result of today's hearing.
Okay. Anything else, Mr. Pekas?
Your Honor, I asked, and also the caretaker actually even asked me if I wanted Joe home today, and I said yes. In my opinion, our friend who was staying with us was here to help me, not hinder me. She also has stated to his lawyer that she will also be defending me on my behalf also, Your Honor.
Okay.
And I was informing him of what my sister was telling me what to do. But Your Honor, I would not do that to him.
Okay. Well, ma'am, just so you know that the child is in the jurisdiction of this court, and the court, when I grant, whatever I grant, that will be an order of the court. If you violate that court order, you could be held in contempt of court. You could be put in jail. So all I'm saying is that whatever that order is, you're going to need to comply with that order.
Yes, Your Honor, I will fully comply with your ruling. I'm not going against it whatsoever.
Okay.
But also, he is not home every day, and he is in child care from all the way till 4 a.m, all the way till he gets home at midnight.
Well, that's always unfortunate, and we'll maybe have to assess that at some point in the future as to what we're going to do in this matter. What I'm going to do on a temporary basis, I'm going to grant to the parties temporary joint legal custody. I'm going to grant physical custody to the plaintiff. The parties are, again, apparently still residing together, so they can work out parenting time in the meantime. If in fact there is no agreement, then the court would grant to the defendant standard parenting time, which is alternating weekends, one night through the week, alternating holidays, etc. Court will grant child support consistent with the child support formula, the incomes of the parties, and I'm not going to do anything as it relates at this point to the psychological assessment. The defendant has represented that she's going to get help for her depression. So, ma'am, when you do get help for the depression, provide that information to Miss Reed so she would have the information as to where you're going, who you're seeing, because the court will at some point want a report from that particular counselor. Anything else, Miss Reed?
Is the defendant's parenting time supervised?
No, I'm not going to do that at this point. Again, depending upon anything happening in the future, the court could review that at that particular time, but I'm not going to at this time.
I have nothing further.
Mr. Pekas, anything else?
No, Your Honor.
Okay, that will be the order of the court. Ms. Reed, you can prepare an order pursuant to 7-day notice of entry, and we'll have that order take immediate effect as of the time of this hearing.
All right, Your Honor.
Okay, thank you. You're free to go. Have a good day. Court will note the appearance of Ms. Reed on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for modification of parenting time and support. Ms. Reed, just to clarify, as I just stated, your petition was for modification of parenting time and support. However, in paragraph 6, you're asking to change custody, and you did reference Vadvarka. So, but your addendum's only asking for change in parenting time. So I'm at a bit of a quandary.
It's only parenting time, Your Honor, because my client was awarded sole legal, sole physical custody. We did get clarification of what that order actually said from November 5th of 2021. It's my understanding that the defendant in this case has not exercised parenting time for the last 2 years, and his parenting time is currently set at alternating weekends. And the only contact my client has had from the defendant in this matter is a parenting time complaint that he filed for a denied parenting time weekend of September 22nd to September 24th which is set for a show cause hearing on Wednesday. So she's requesting, because there's been significant domestic violence that the child has observed, that and the span of time that he hasn't exercised parenting time, that he engage in reunification counseling before he receives any parenting time, have parenting time classes, and that the parties communicate through our family wizard and exchanges occur at the police department.
Okay, thank you. Well, what the court's going to do in this matter, the court is going to continue the, again, the parenting time, but I'm going to order that the parties would engage in reunification counseling prior to the commencement of that particular parenting time. The court would order that the parties would communicate through our family wizard, that when the exchanges occur, that they would occur at the Battle Creek Police Department. The court would set support consistent with the support formula and guidelines in this particular matter. And the court would order that the defendant would, well, that the parties would agree upon a reunification counselor, I'd say within 21 days of today's date. If they can't agree, then they'll bring the matter back before the court, and that the parenting time would not commence until, again, that reunification counseling proceeds.
For language of the order, would it be appropriate to put parenting time commences at the recommendation of the counselor?
Yeah, we can do that. You can put that in, and then we'll get a recommendation and see how that proceeds.
All right. Thank you, Your Honor.
Anything else, Ms. Reed?
No, Your Honor.
Okay, thank you. The court will note the appearance. Have a good day. On behalf of the defendant, the matter is before the court on the defendant's notice for entry of particular orders. The front of the court had previously filed objections. Ms. McNiff, have those objections been addressed?
Your Honor, I could address the support order with no problem. It's just a matter of checking the modified box as opposed to the final box. But the bigger problem is the front of the court wants us to designate physical custody as well as legal custody. As the court knows, there's only one kind of custody, and that's custody in the Child Custody Act. This is that case that's been pending for a long time, where the child was with the great aunt for a period of time. The parties finally have an agreement. Mr. Schaefer and I think it's a good agreement. The parties like the agreement, but there is an objection to designating Ms. Franey as having sole physical custody of the children. We do have a parenting time plan that's specific. It's essentially a standard parenting time plan. I think the court, if needed, could always determine established custodial environment based on the parenting schedule. I don't think having a physical custody designation is necessary. The parties do agree on joint legal custody, and that's really the only issue that front of the court has at this point.
And that's, I'll tell you, just because it's come up in some other cases as well. And the court does have an issue with, again, not designating someone as a physical custodian. So
we can go back and try to negotiate it. I'm trying to get some finality with this case since it's been hanging out there for a while.
I understand. See if you can't come up with something. I know this come up with Ms. Thomas previously, and what we did is the issue was we just simply designated the parties as having joint. There wasn't any third parties in that case, so it was easier. We designated them having joint physical, and then we spelled it out under the parenting time schedule as to how it was going to work.
So would you be okay if we call it joint physical custody, but keep a standard parenting time?
Yeah, there's no problem with that.
Okay, I'll talk to Mr. Schaefer and we'll see if we can get the parties to agree on that. The third party is no longer at issue. The parents are completely have the children at this point, but the old still designates the children to be with the great aunt. So we do want to get this cleaned up.
Okay. Well, why don't you check with Mr. Schaefer, see if you can't come to a resolution, and then we'll do a new order, and the front of the court should not have a problem if there's that designation.
That sounds good. Thanks, Judge.
Okay, thank you. Pays no on behalf of the plaintiff, Ms. McNiff on behalf of defendant. This matter is before the court on the defendant's motion for temporary custody, parenting time, and support. Ms. McNiff.
Your Honor, I'm sure you've already read our motion. I'll update you, but the minor child did spend a night with dad recently. However, that was fraught because dad only has 2 bedrooms, and in the guest room, he only has 1 bed. but the parties have 3 children, even though 2 of them are adults. That becomes problematic. When Lauren spent the night with Dad recently, she slept in the bed, but her brother Owen had to sleep in a chair. Owen is 18, he goes to college. There's also a 21-year-old adult son, Quinn, who goes back and forth between the parties. So there simply isn't space for Dad to have Lauren on a 50-50 basis. At Mom's house, Lauren has her own room, Mom has her own room, and the boys, when they're both there, share a bedroom. So it's a more appropriate environment. We think it's going to be difficult for Lauren in this situation, even on a standard parenting time basis, but a 50-50 basis is just absolutely not tenable at this point. Why Dad didn't get 2 twin beds or bunk beds or something like that so that the kids don't have to alternate sharing the bed also is problematic. But we would ask that at most Dad be granted a standard parenting time situation. We've also asked for sole legal custody primarily because mom is a nurse. Mom has taken care of the child's Graves' disease for her entire life since she's been diagnosed with it. And Mom is the one who makes the medical decisions. To have to involve Dad in making all of those medical decisions will make it more onerous for her. And so we are asking for sole legal as well as sole physical.
Okay. Ms. Page, now your response.
Your Honor, I'm hoping the court received my response regarding this. A couple of things in regards to my client's residence. They do have 3 children and 2 of them are adults. The 18-year-old that's been staying with him goes back to school tomorrow, and he did not sleep in a chair. He slept on the couch. My client does have ample room for Lauren to stay with him and has taken her shopping to buy her supplies like shampoo and all the things that she would need it there. There have been no problems with her spending the night with my client, and it has been more than one occasion. I do believe that prior to these parties' separation, they did both share the established custodial environment as they both were actively involved with Lauren in regards to her schooling. Recently, Lauren changed schools this year from now going to Marshall, where she's not doing the greatest. My client's been involved in getting her enrolled in tutoring, making sure that takes place on Dad's parenting time as well. The parties have been free and flexible in regards to parenting time, but we're also dealing with a 14-year-old who has sports and friends that she likes to be involved with. My client, although doesn't live in Marshall like Mom does have the ability and has talked to his superior at work to be able to get her to and from school. He has been involved in her medical decisions as well as her medical care during the marriage. My client would have to not be able to spend the night at times because during surgeries, because they had 2 other children at home that needed to be taken care of as well. So Mom did primarily do that. However, my client has the ability to make sure the child receives any medications, get her to any doctor's appointments, and take care of her on that end as well. We do believe that joint legal custody is appropriate due to the fact that the parties have both been involved with the minor child and her medical care, and decisions that have been made since then have been made jointly, such as switching schools. And we would ask that they have joint physical custody. As I indicated, my client can get the minor child to and from school on time and does have a proper place for her to stay. We would ask that child support be sent per the formula, but this court order joint legal and joint physical custody.
Okay. Ms. McNiff, any response?
Judge, just that I think the problem is going to be even getting this child to go with Dad on 50-50 basis. That's been difficult to get her to go, to the best of my knowledge, for one overnight. So I think 50-50 is going to be problematic.
Yeah. Well, the court does note that based upon the pleadings that the plaintiff has had very limited parenting time since the parties separated. Again, as stated here today, there was only 1 overnight in this particular matter. What the court is going to do is the court is going to grant to the parties joint legal custody, physical custody to the defendant in this matter, that the court would award to the plaintiff standard parenting time, provided that the child does have her own bedroom while she is in his particular care. So I don't want her sharing it with the adult brothers or any other third parties. She'll have her own bedroom when she's in his particular care. The court will enter support consistent with the guidelines and the child support formula. With that, anything else, Ms. McNiff?
No, Your Honor.
Ms. Page, no?
Nothing further.
Okay. Thank you, Ms. McNiff. You can prepare that and submit under 7 day. That will conclude the hearing. You have a good day.
Thank you, Your Honor.
Mr. Umlauf on behalf of the defendant in this matter. This matter is before the court on the plaintiff's motion to show cause. Ms. Garreau, I have read your pleadings as well as Mr. Umlauf's response. Is there anything else you'd like to add?
Yes, Your Honor, there is. In regards to under his motion and affidavit, number 2, he denies as untrue. I deny that. I was awarded 50% half. And under number 3, I deny that. It was abuse in plain sight. And under number 4, I deny that. It is not true. He received a letter from me in March and never responded. And Mr. Umlauf could have asked the court for more time.
Okay.
And then,
ma'am, let's get to the meat of the issue. And it sounds like, that based upon Mr. Umlauf's response, and I think you had repeatedly stated that the Newell Brands had in fact honored the request for the pension, that you received those funds. Is that correct?
that is correct, Your Honor, but that does not make me whole. I was whole when I left the marriage and was awarded 50%. And then having to go through all of this court battle with the court system, Newell Rubbermaid, all my costs involved.
Okay,
the fact that I was
let me ask you this, ma'am, and unfortunately, I'll tell you, because you represented yourself, that is in fact an issue, and a lot of what you went through is stuff that attorneys would be doing if they had represented you. In these matters, it's not unusual that companies will change, they'll merge, they'll be bought up, et cetera, and oftentimes the attorneys have many issues to attempt to locate and get the correct entity that it now handles and carries the insurance, or not insurance, I'm sorry, the retirement or pension, et cetera. So it's not unusual what you went through to collect that when you're dealing with those particular entities, as opposed to what you do dealing with the defendant. So the court is more concerned about what the involvement or what your relationship was and what happened with the defendant, as opposed to a third party that he has no control over. So what was there that you claim that he didn't do that he should have done, as opposed to a third party?
He should have not withdrawn and depleted the account. I was awarded that amount.
Okay, you received that amount though, ma'am.
Yes, I know, but after much, okay, you're saying that if I would have hired a lawyer, which I had to help myself because I cannot afford a lawyer. I have not been able to work. I'm living off of my savings.
Okay, ma'am, this is all extraneous. I just need to know what it relates to your particular motion.
What it relates to is I was whole when I divorced.
But you have not, but ma'am, you've now since, ma'am, you've since received all the money you were supposed to receive pursuant to the terms of the judgment of divorce. Isn't that correct?
Your Honor, I have received my funds, yes, but I have not been made whole. I want to be made whole.
Okay.
I had to go through whether I hired a lawyer or not. This is about gender discrimination. Okay. This happened to me because of gender discrimination. And I had a lot of suffering. I had to help myself. And now I'm being told, because I helped myself, that, and I've been paid funds, that all that my ex was allowed to do to me, that was okay. Well, that was not. Now I need to be made whole again. I had to, whether I've hired a lawyer or whether I did it myself, I had to go through so much more to get the 50% that was awarded me. And that's not right. You can't just destroy somebody's life and then go, ha, 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 and commit a crime and say, now you pay for it. It doesn't work that way, Your Honor.
Okay. Ma'am, what I was trying to highlight to you before when I started is that happens in a lot of cases. It's not just your case. That oftentimes when you're dealing with companies with pensions and retirement programs, that is not unusual. Some of the things you experience that you would experience those. And that's the only reason I brought that up. So you would know that it wasn't anything unique or simply pertained to your case. So with that.
Your Honor, I understand that.
Okay.
And this problem is bigger than me. Okay? But I'm focusing on just my case.
Okay, thank you. I'm gonna let Mr. Umlauf speak. Mr. Umlauf, I have received your response. Anything else?
I would note that the allegations that criminal activity took place are simply false. The August 16th letter shows that she was indeed made whole. What happened here is my client believed that everything was in order and that the account had already been divided up when he took his lump sum payment, and I believe it was 2015. It's unfortunate that that happened, but again, she has been made whole. And so for that reason, and Your Honor certainly knows it's not unusual that even attorneys sometimes have trouble getting QDROs prepared and getting them to conform with the specifications of each individual company and pension carrier. That can happen. But ultimately, my client did not do anything wrong. He did not do anything to harm her. He did not impede the process. It was the defendant's responsibility to prepare these QDROs and get that money. It took her much longer than ideal to do that, but it was not his responsibility to prepare them.
Okay.
Thank you.
Thank you. Anything else, Mr.
Yes, I deny that. It was a court order that needed to be followed by law, and he knew what he was doing when he withdrew all of the amount, and I did do nothing wrong. I turned in my quadro. It is a court order that needs to be followed by the law, and for him to be able to reach out after the divorce to cause me harm does constitute a crime. A crime under Michigan law states that crimes caused by some type of action that can cause extreme harm psychologically are classified as a felony. This defendant's statement by the attorneys and our unfounded claims under Michigan law is gender discrimination, as these types of cases are typically women's issues that are not covered for what they truly are, evil crimes. Although I have lumped
well, ma'am, just to clarify, I will tell you that in these, over the years, I've seen these instances, and again, they're not unique to the female gender, that in fact, when men have had received a QDRO or something, they've been in my court time trying to get enforcement of that, or have had difficulties with the companies just as you experienced. So I'm not minimizing the fact that it may occur more with women, but we've had enough occasions where it's occurred as it relates to men getting QDROs entered and getting them paid, et cetera. So,
Your Honor, I'm not saying that you are. I'm saying it is discrimination.
Okay.
And I'm saying that there is a court order, and a court order must be followed by law, and no one, not Newell or Douglas Giroux, have a right to not follow that court order.
Okay.
And that court order was not followed in plain sight by Mr. Giroux when he took out that money. He knew that. He was aware of his balances. He didn't need the money. Why would he have done something like that? Why would he have reached out after the divorce to cause me harm? You know, I left him to get out of that divorce.
Okay. Ma'am, again, you're going into extraneous things that don't apply to this particular motion. So I just want you to confine
Okay, well, I'm
yourself to the
asking
motion.
why. The burden of proof is on him.
Okay.
What happened to the other half of the money? The pension laws are you have to be 55 and older before eligible. He withdrew money at 52, and that was half. What happened to the other half before that?
Okay.
And how was, those are the issues, Your Honor.
Okay.
They're in plain sight.
Okay. Well, in this particular matter, the court will make the following finding: that in this case, the plaintiff does acknowledge that she has, and she acknowledged that in her pleadings as well as in court today, that, again, there were some issues on the collection of her portion of the pension pursuant to the QDRO, that the QDRO was delayed substantially for a period of time as she was preparing those particular pleadings, that, again, the company, Newell Brands, subsequently did honor her request, that she received all of the monies that she was supposed to receive in this particular matter, although they were, again, delayed. But again, the court doesn't find that as being unreasonable. It's unfortunate, but it's not unreasonable that it does happen. As a result, the court does not find any willful, intentional conduct on the part of the defendant in this particular matter. Maybe he withdrew that, maybe it was an error, but it was subsequently remedied in this particular matter, and she was paid the full amount that she was entitled to receive under the terms of the judgment of divorce. The court does not find a basis for the show cause. The court will deny the petition in this matter. Mr. Umhoff, I'll ask that you would prepare an order denying the motion and concluding this matter. So thank you both. You're excused. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Dylan Luke versus Maya Moore. Attorney Jesse Fernandez is filling in for Attorney Sharp.
Okay. Good afternoon to all of you.
Good afternoon.
Can you hear us, Attorney Fernandez?
He's muted.
His video is off too. We're ready.
Thank you.
Mr. Fernandez, as you represent the plaintiff, I will check with you first. What issues do you believe to be in dispute in this case?
None, Your Honor. I actually had an opportunity to speak with Ms. Moore in a breakout room before this. The parties have come to a full agreement on custody, parenting time, and child support. So I'm not sure if you'd like me to place that agreement orally on the record or just submit it via a consent order signed by the parties.
Well, we've got the parties present. Why don't we do that? We can put it on the record now, and then that way you can simply just write it up and we don't have anybody changing their mind 15 minutes from now.
Definitely. Yeah, that works.
Okay.
Yep.
Go ahead, Mr. Fernandez. What is the agreement?
So the parties will share joint legal custody and joint physical custody of their child. Parenting time shall be equal 50-50. Plaintiff father shall have parenting time Wednesday starting at noon through Saturday at noon. Then the defendant mother shall have parenting time Saturday at noon through Wednesday at noon. And the holiday and break parenting time will be pursuant to the Calhoun County parenting time policy. And child support, the parties have agreed to deviate to 0 for child support. Plaintiff will carry the minor child on his medical insurance, and each party shall claim the child on alternating years for tax purposes. Plaintiff shall claim their daughter on even years, plaintiff shall claim their daughter on odd years, and defendant shall claim their daughter on even years. And I believe, other than the Hague Convention and other language, that resolves all the issues in this case.
Okay, let me just ask one question. Is the child receiving any public assistance, or the parents receiving public assistance on behalf of the minor child?
Not anymore. I called and canceled everything that we had going through the state, which was insurance, WIC, and food card, and everything that's been canceled.
I think that would have been the only holdup. You couldn't deviate to 0 if, again, if you were getting public assistance. So I'll ask you, Ms. Moore, you've heard the Mr. Fernandez state what the agreement is. Is that your understanding of the agreement?
Yes.
And are you willing to accept a judgment which would contain the provisions as outlined by Mr. Fernandez?
Yes.
Has anyone threatened you, coerced you, used an undue influence, pressure, or promises to get you to agree to this arrangement?
No.
Do you believe that this arrangement is in the best interest of your child?
Yes, I do.
Okay. Mr. Fernandez, if you want to inquire of your client.
Thank you, Your Honor. Mr. Luke, did you have a chance to hear the agreement that I just read into the record?
Yes, sir.
And do you have any questions about it?
No, sir.
Okay. And do you agree to be bound by the terms of that agreement?
Yes, sir.
And no one's coerced you or promised you anything to get you to agree to that arrangement?
No, sir.
And as part of that agreement, there are going to be provisions regarding custody, parenting time, and child support. Do you believe that those provisions are in the best interest of your child?
Yes, sir.
Thank you. I have no further questions. Your
Okay,
Honor.
thank you. Thank you. And the court state that it's admirable that you've been able to come to an agreement. I'll tell you, it'll be much better for you as you go forward if you're able to agree on various things rather than have the court to have to come in and maybe do something that is not acceptable to either of you in this particular matter. So you're to be commended for that. And Mr. Fernandez will prepare the paperwork, and you're free to go. Have a good afternoon.
Thank you,
Mr.
Your Honor.
Fernandez, I want you to hang on a
Your
minute
Honor.
if you could.
Yep.
Mr. Fernandez, we spent a little bit. We haven't got an update on Tara. How are things going with her?
She is stable. I think still might need a few more surgeries. But she was in the trauma unit for a while and then got moved to Mary Free Bed for a short stay, but now she's back home with her family. But can't put any weight on her leg for a few months. And still, figuring out what surgeries are upcoming and things, but she's stable. And we're just glad she's alive. Some of the pictures were.
Well, we saw some of the pictures, and our court administrator, Chris Getting, is obviously related. Her husband's the prosecutor, so Ken Tara's sister works for her, so we've been getting things back that way. But
definitely
nothing more than that. We hadn't heard for a couple of weeks, so I was just curious and hope she was doing better. It sounds like she's maybe out of the woods, but a long way to go.
Definitely, yeah. I think that's a fair assessment.
Okay,
That's good. I'll put you back in the waiting because I know we have one more case with you.
Okay.
Yep.
Thanks for the update. And if you see her, tell her we're
And
thinking about
Attorney
her.
Bendeley is filling in for Attorney Buckling for plaintiff. Defendant is not here.
Ms. Bendelay, enlighten me. What's happening?
It's my understanding, Judge, I suppose if the court will recall, there was a scheduling conference on December 4th. Attorney Buckland had indicated he believed that he might be able to reach an agreement, or the parties might be able to reach an agreement. It was my understanding that they had in fact reached an agreement, which I was prepared to place on the record today. Obviously, the opposing party is not here. To that end, what I would just ask, I believe, is that the court sends the parties to mediation at this time.
Send the parties to mediation?
Yes, Your Honor.
Okay. Well, okay. What issues do you believe are in dispute?
Well, again, I had thought that there was an agreement based on Attorney Buckland's notes. So frankly, I don't think there is anything in dispute, but I was hoping that we could take proofs today, but obviously defendant's not present.
Well, we can take proofs regardless of the defendants here. So why don't we do this if there's no, I don't want to go through and do a whole scheduling order if you do have an agreement.
Right.
So when we take proofs, we'll reschedule it. We'll put a status conference for about 30 days and find out what's happening. And perhaps we'll have resolution by that time.
That works for me, Your Honor. And just for the court's reference, Attorney Buckland, I believe, was beginning to prepare a judgment divorce, but he obviously doesn't have that for the court yet.
Ms. Bendelay, you can proceed.
Thank you, Judge. Ms. Wright, throughout the course of this action, have you been working with Attorney Buckland to resolve the matter?
Yes.
And do you believe that you and Mr. Rice have reached an agreement as to the division of your property and the custody of your child?
Yeah.
Okay. As to real estate, is it true that there's no real estate to be divided among the parties, as any real estate is owned by a third party trust?
Yes.
And is it also your understanding that each party would keep their respective bank account or credit union account in their respective name?
Yep.
And as to retirement, is it your understanding that each party would keep any respective retirement that they may have?
Yes.
As to life insurance, is it your understanding that each party would be awarded any life insurance policy that they are the owner of?
Yep.
And as to vehicles, is it your understanding that you would be awarded a 2016 Jeep Wrangler subject to any debt? You would also receive a 2014 Chevrolet Traverse, which will be signed over to your son. It's
already been signed over.
Okay, so the only thing that you would receive then would be that 2016 Wrangler?
Yep.
Okay, and then conversely, Mr. Rice would be awarded his Chevrolet truck?
Yep.
And to your knowledge, is there any other jointly titled vehicle that the two of you share?
No.
Okay. As to personal property, is it your understanding that each party would keep any respective personal property in his or her possession, subject to any debt, except that you would receive a China hutch, a Gravely zero-turn mower, your personal items, the kitchen table, and another hutch?
Yes.
Okay. As to debt, is it your understanding that each party would keep any debt in his or her respective name?
Yes.
And as to spousal support, is it your understanding that there would be no spousal support and spousal support would be forever barred?
Yes.
As to the custody, support, and parenting time of your child, can you please state for the court how old your child is?
He is 18.
Was he 18 at the filing of this action?
No.
Okay. Is it your understanding that the parties have agreed to joint legal and joint physical custody of the minor child, and that parenting time would be as the parents can mutually agree, taking into consideration the age of the child?
Yep.
And would it be also your understanding that this child support would be deviated to 0 given the age of the child and the timing under which he'd be under the court's jurisdiction?
Yeah.
And do you understand that we would have to include this because the child is still in high school?
Mm-hmm.
Okay. Do you wish to be restored to your maiden name or have the option to do so?
Yeah.
And could you state your maiden name for the record, please?
Salyer.
And at the filing of this divorce, were you a resident of the state of Michigan and of the county of Calhoun?
Yes.
And at the filing of this divorce, did you believe, or I suppose now, do you believe that there's been an irretrievable breakdown of the marital relationship such that the objects of matrimony cannot reasonably be reconciled? In other words, there's no hope of you getting back together.
Correct.
Are you currently pregnant?
No.
Okay. Do you believe that the agreement that we placed on the record is a fair and equitable distribution of your marital property?
Yes.
Do you also believe that the custody arrangement that we placed on the record today is in the best interest of your son?
Yes.
Is there anything else that you would wish for the court to know at this time?
No, other than he keeps violating the PPO order.
Okay, I mean, as to the divorce at least, but that resolves everything else.
Yes.
Okay, I have no further questions, Judge.
The court is satisfied that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs pending receipt of the approved judgment of divorce, UCSO, and other paperwork. You're not divorced until we actually sign that order, ma'am, so it still may take a few weeks to get all of that done. But at that point, best of luck to you. I hope everything works out for you. And you're free to go today. Have a good day.
All right. Thank you.
Okay. This is the time and place set for the scheduling conference. And the scheduling conference, for your information, Mr. Naylor, is where we put in place various dates and procedures so that the case would proceed in an orderly fashion. I will go to Ms. Paisno first because she represents the plaintiff. Then you'll be given an opportunity to have some input as well. So, Ms. Paisno, what are the issues that are in dispute in this case?
Your Honor, I believe that paternity is at first at issue. There has not been any DNA testing or, in my knowledge, any affidavit of parentage signed by either party. I note I was going to default Mr. Naylor. However, I realized that he has filed an answer. However, my client or myself have not received a copy of it. So we would need him to serve us with an answer to the complaint for paternity. So paternity is an issue. And then once that's established, custody, parent time, and child support would become an issue if he's deemed dad.
Okay, well, let's get, we'll get that resolved first. Mr. Naylor, send a copy of your answer to Ms. Paisno as we are required to do so by court rule. And then it looks like we'll probably have to do some DNA testing at that point. And once that's completed, then we'll proceed with all the other, depending on what the results show. Court's probably going, what I'm going to do is reserve on the scheduling order. I don't want to put that in place because it entails a lot of other things that you need to get resolved first before that. So, Ms. Paisno, I'll leave it up to you to kind of orchestrate the DNA testing and all of that. And
so I have a motion up next week on that in order for that to facilitate that. It's in front of you next Monday at 9:30.
Okay. Mr. Naylor, again, you heard Ms. Paisno has said that there's a motion coming up next week for that.
Yes, sir.
Let me ask you, do you want to go through with a DNA test?
Yes, sir.
Okay. Then there's no reason to have them come in on next Monday. We can just agree. I'll let Ms. Paisno do an order requiring the DNA test and that all parties cooperate to do so. Ms. Payson, the only thing I would ask, I don't know if you have a entity that does that, or you could talk to Mr. Magnuson at the front of the court. Sometimes they will allow you to go through and do it through there, and it's a nominal amount. I think it's like $25 or something if you do it through there.
Yeah, and the only issue I foresee is I do have places that I use here in Michigan, but Mr. Naylor's in Minnesota. So I'm not sure how, we're gonna have to coordinate something that way, or he's gonna have to come here to do the testing.
Okay. Well, I don't assume he wants, Mr. Naylor, you don't want to come to Battle Creek for testing, do you?
No, sir.
Okay. Well, we'll have to coordinate that, and I'll leave that up to Ms. Payson to do so. But I'll simply order that the parties would cooperate and do the DNA testing within 30 days of today's date so that we can get it done. I don't want to drag this thing out, and I'll have you cooperate with Ms. Payson, and she can arrange to coordinate it with where they're gonna have to get this done. So
sounds good.
Okay. Anything else?
So you're gonna cancel
Yeah,
that
we'll-
hearing for Monday?
Yeah, we'll take that off, and that's for any reason you really want to come. And
No, it's all right.
okay,
So
Mr.
that's here next week. Okay.
next
so-
week 9:30.
Oh,
Mr. Naylor, anything else that you have?
No, sir.
Okay. Well, you'll get an order from Ms. Payson. I'll let her do it under basically a 7-day notice of entry because everybody's agreed to it. So there's no reason to have that. You'll get that. She'll be contacting you in the interim so that we can try to get the
Attorney
blood
David
test
Sebastian
done and
for
get this
plaintiff,
complete.
Attorney
Okay.
Jonathan Vanderhorst for defendant.
Good afternoon to everyone.
Good afternoon.
Mr. Sebastian, I've been informed that you had resolved the issues in this particular matter and simply wanted to put on proofs. Is that correct?
That is entirely correct, Your Honor.
Okay. Mr. Vanderhorst, is that accurate?
Yes, it is, Your Honor.
Okay. Mr. Sebastian, go ahead.
Thank you very much, Your Honor. Mr. Halleck, were the allegations contained in the complaint of divorce true at the time that you signed it and filed it with the court?
Yes.
And do you have children of this marriage?
Yes, I do.
And did you and Keely come up with a parenting plan that you deemed to be in the best interest of your minor children?
Yes.
And did you agree to joint legal custody with Keely of the minor children?
Yes.
Is there any chance that you and Keely could reconcile if Judge Kirkham were to refuse to sign the judgment?
No.
Did you sign the proposed judgment of divorce?
Yes.
And did you understand it when you signed it?
Yes, I did.
Okay. And did you do you understand that if you did not resolve this in mediation, you could have gone to trial before Judge Kirkham? You could have done better, could have done worse, or you could have done about the same?
Yes, I do.
And are you asking the court to approve the judgment of divorce that you have signed?
Yes, I am.
Do you believe the marital property is being equitably divided between you and Keely?
Yes.
I don't have any further questions, Your Honor.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the paperwork and the approvals. I'll tell you both that you're not divorced until I actually sign that final judgment. So it still may take a week or two. I don't know where the process is with getting the paperwork to the front of the court for approval and getting it back into the court. But we'll try to get that done as soon as we can. So you're free to go today. Best of luck to both of you. I hope everything works out for you, and have a good day.
Thank you very much, Your Honor.
4 p.m.
Thank you, Your Honor.
Attorney Luke Dillon for plaintiff and Attorney Capture for defendant.
Okay. Good afternoon to everyone. I
Afternoon.
will start with you, Mr. Dillon, as you represent the plaintiff. Tell me what's happening in the case.
So what's happening, Your Honor, is that there's a few things that are slowing up the process a bit. One, there is a charged domestic violence that it's in warrant status in Calhoun County against Miss Fugate, Larry Morris being the alleged defendant. He's also in felony non-support status with the FOC. That is not with the AG's office yet. Where we're at, Miss Capture proposed a very good judgment and resolution, which is once the domestic violence is resolved and the felony non-support is at least taken out of felony status, then we can put together a judgment or a judgment that shows what the parenting time, what the child support, and what the legal custody could be. But until we get the domestic violence and the felony non-support out of the way, this case is kind of dead in the water right now because there's a no contact order
Oh, under the,
criminal case.
okay.
No, there's a PA 53 in place.
Okay, when do you anticipate that that's going to happen, that you're going to get resolution of the criminal? I'm not so concerned about the felony support because we can enter a judgment notwithstanding that. And you said that it hasn't went to the AG, so that seems like that would be easy enough to take care of.
I believe so. I was just meeting with my staff about it. I want to have a conversation with Mr. Morris at least by Friday. And if it's not, we don't have some resolution by Friday, then I think that Ms. Capture could just put at least a judgment together because I think her resolution, I don't know if she's ran it by Ms. Fugate yet, but her resolution is a good one.
Okay. And Ms. Capture, tell me, is that something you can do if we can get identify how we can resolve the other issues by Friday or something, that you can put together a judgment?
Yeah, if we can get some movement on this, I don't mind at all getting a judgment together and meeting with my client and what would be reasonable there. But we haven't been able to have a lot of movement simply because of the status of those two issues.
Okay. Well, what the court will do is I'll reschedule this for approximately 30 days, give you that 30 days to get some resolution. And if not, at that particular time, we'll set the matter for trial if again, we don't have resolution. I will tell you, because of timing and some things of that nature, you'll be put on a pretty short schedule. So if we come in 30 days and we don't have resolution, be prepared to try this in about 2 weeks.
Yes, Your Honor.
Okay. Okay, thank you all, and you're free to go. Have a good day.
Thank you.
Attorney Fernandez filling in for Attorney Sharp for plaintiff and Attorney Sachs for defendant.
Okay, good afternoon to everyone. Court will note that this matter was before the court for a revocation of paternity hearing back on November 1, 2023. Ms. Sharp at that time was to prepare an order under a 7-day rule that did not get prepared. And I know Ms. Sachs has then filed an appearance in this particular matter. Ms. Sachs, enlighten me, what's your position in this matter?
Your Honor, the parties have come to a full settlement in this matter. We submitted the order this morning to the court, including the child support order, and we're just waiting on the FOC approval, and then we would ask that this court sign that order.
Okay. Mr. Fernandez, is that your understanding?
That is my understanding, Your Honor.
Okay.
Yes, we attended mediation last week and were able to resolve everything.
Okay. Well, great. What we'll do is we'll simply await the receipt of that order. We can get that entered then once we have the approvals, and that will complete the case. So best of luck to both of you, and you're free to go. Have a good afternoon.
Thank you.
Okay.
Thank you.
Good afternoon
Thank you,
to both of you. I'll go with you first, ma'am. I note in this case that mediation didn't take place back on November 10th. And the case didn't get settled, but I did have a note that the parties were requesting additional mediation. Did you have the time to, and have you done additional mediation since that date?
Since 11/10, yes. So the schedule, we had it scheduled after the 10th to meet again on 12/7. And the mediator had a family emergency, so we rescheduled to 12/15. And then from there, Brian had conflicts, so we ended up meeting on 1/5, so last Friday, for 1 hour.
Okay. And did you get resolution at that time?
We did not. It was cut very short, which I was surprised by. So, yeah, I was hoping to, continue through the conversations for the rest of the duration of the time we had set aside.
Why was that it was cut short?
I don't know exactly what triggered it. The mediator came back and after she had spoken with me, and then she went back to speak with Brian, and then came back to me and said, we are not going to continue any further mediation at this time. I'll refund your money for the last 2 hours, and, just expect that.
Well, what that signifies to the court is that, again, you gotten to a point where resolution was not going to be possible. And so she just discontinued mediation rather than have you engage in a futile exercise at that particular point. So it looks like I'll ask the defendant, Mr. Van Tattenhove, does it appear that obviously resolution isn't going to happen in this matter? We have to have a trial?
Can you hear me?
Yes.
Yeah, I believe that is I think that's what needs to happen. I was informed during that mediation that sometime in November, Mrs. Van Tatenhove liquidated an additional $30,000 out of a 401k account that was listed as an asset.
Okay, well.
And so to me, there's nothing left to divvy up or come to a resolution on because the assets are gone.
Well, you can still divvy those up and divide those if you were going to agree that they would be divided in half. And I'm not saying that they are, but if you agree to that, she simply would have to come up with that half to again make that occur. So what we'll do is, if it looks like we've reached maybe an impasse, the court will set the matter for trial. Then you will have to be here and try the case, and the court will make a decision at that point. So do either of you have a vacation coming up, or sometime you're going to be out of state, out of the country, anything of that nature?
Not to my knowledge.
Okay, ma'am, you? Okay.
No, sir.
Okay, we'll have our staff get in touch with you, and we'll come up with a mutually agreeable date. And what is that the only issue then? Are the property issues, or are there any child-related issues?
It's my understanding that we agreed to 50-50 custody.
Is that your understanding, ma'am, or not?
Yes, sir.
Okay. Well, then what happens on that basis, the court will set the matter for trial on the issues of property only, as it appears from what you said that you do have an agreement as it relates to custody, parenting time, and support issues. So we will be in touch with you and find out when you're available. We can then set up for a trial.
Okay, how will you be in touch? Will I get a letter or?
No, we will call you.
Okay.
And you probably will get, it might not be yet today, but it should be by tomorrow that you'll get a phone call.
Okay. Do I have permission to speak? I just want to say one thing in, I guess, response to what Brian just said about taking another 30.
No, we don't need to do that because we're going to address that at trial. So.
Okay.
And that'll be a matter of proofs at that particular point. And you can talk to him at, side on your own if you want to make an explanation or see if you can't resolve it, that's fine. But we're not going to resolve that today, so we'll just set up a trial.
Understood.
Okay?
Yes, sir.
Okay, thank you both. You're free to go. Have a good day.
Thank you.
Mr. Sackrider is here from the Public Defender's Office.
Okay. Good afternoon, Mr. Sackrider.
Good afternoon.
This matter is before the court, alleged personal protective order violation. I will note in this matter, and I'll advise Ms. Atchison in this case. Ms. Atchison, you have various rights in this matter, and I'm sure maybe your attorney has advised you of those. You have the right to be advised of the alleged violation. The alleged violation is that on January 7, 2024, that you did enter the petitioner's residence at 51 Michigan, and that you then did contact or communicate or attempt to contact and communicate with the petitioner in this matter. You have a right to contest the charges. You have the right to an attorney if you cannot afford an attorney, and the court believes it'll impose jail time. The court will appoint an attorney to represent you at public expense. We have Mr. Sackrider here for that purpose. You have a right to remain silent and not have that silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses, and you have the right to ask that the court would compel those witnesses to appear in the event that you would not, they would not appear in this case. I will let you know that we did get a appearance from the prosecutor in this particular matter, that the prosecutor has asked for an adjournment of not less than 14 days in this particular matter. I will then leave it up to you, Mr. Sackrider. After hearing the allegations, are you going to enter a plea on your client's behalf?
We would enter a not guilty plea today, Your Honor.
Okay. The court will accept the not guilty plea at this particular time. The court will note, based upon the request of the prosecutor, the court can adjourn this or adjourn the matter out for the actual hearing. The court will set that hearing on January 25th, 2024 at 8:30 a.m. And we can take care of the matter at that particular point. Mr. Sackrider, is there anything else before we conclude?
I would ask my client be released pending that trial date, Your Honor.
Okay. And I don't have the prosecutor here to speak to the issue of bond, but Mr. Sackrider, what are your thoughts as it relates to bond in this matter?
Yes, it's my understanding that my client does not have the an ability to post a bond at this time. This is for an alleged violation of a personal protection order. My client has entered a not guilty plea. I'm looking through this police report. I do believe this was a non-violent offense or allegations. And we would ask that the court put in place a no contact $0 conditional bond pending the hearing date that the court stated earlier. Thank you.
Okay. Well, the court does take these matters serious. I do note that, again, the allegation, these are only allegations that your client did enter the premises. She then took pictures in the premises and sent those to the petitioner, obviously to show that she was in the premises. And obviously the court's concerned about that. But what I will do, there's not a history here. Court will go along with what Mr. Sackrider's asked for, and I will have you released, Ms. Atchison, on a zero bond, meaning you don't have to post a bond. You'll be able to get out. I will tell you that the court will, however, as a condition of that bond, have you that you have no contact with Mr. Powell, that you don't enter his premises, you don't contact him in any way. If you do, the court will revoke the bond and put you back in jail. You understand that, ma'am?
Understand fully.
Okay. Okay, the court will, that will take care of this matter. The court will further order Ms. Atchison to, I'm going to put an order in place for fingerprints. So they will take your fingerprints in that, Ms. Atchison, before you are released in this particular case. So anything else, Mr. Sackrider?
No, nothing further, Your Honor.
Okay, thank you. That order will, it'll take Ms. Atchison, it'll still take a bit of time for that order to work its way through into the sheriff. So you're not going to get out in the next 5 minutes, but you should be able to get out here shortly this afternoon. Okay.
Thank you.
Okay. Thank you. That will conclude this matter at 2:24 p.m. You're free to go. Have a good day.
Thank you.